Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida, and I'm going to talk today about trade secret litigation and merits defenses. I'm going to preface this conversation by telling you why you should watch this video and why you should listen to what I have to say. Number one, a lot of attorneys are generalists. They practice in a number of different areas. They're jacks of all trades and masters of none. 80% of our practice is non-compete and trade secret litigation. We focus in this area, we tend to stay in this area, and that has allowed us to develop a certain amount of subject matter expertise. Over the past few years, I have been interviewed on non-compete and trade secret issues by numerous different publications at the state and national level. I have won trade secret cases. I have prevailed in recovering attorney's fees for successful defense of trade secret claims. I have taught continuing legal education courses to dozens of other attorneys regarding non-compete and trade secret related topics. I am admitted in the United States District Courts for the Southern, Middle, and Northern Districts of Florida, along with the United States Court of Appeals for the 11th Circuit. I have successfully prevailed on appeal in the U.S. Court of Appeals for the 11th Circuit. I'm a Phi Beta Kappa magna cum laude graduate of Cornell University. I attended law school at Georgetown, where I was an editor of the Law Review. In short, you should pay attention because I take this very seriously. I aim to be the best at what I do, and I'm going to give people some insights into trade secret merits defense. So without further ado, merits defense is not to be confused with an affirmative defense. A merits defense goes directly to the core of whatever the claim is. In the trade secret context, the core contention is you stole trade secrets. This gives rise to exactly two merits defenses. One, it's not a trade secret. Two, we didn't steal it. Today I'm going to focus on the first of these, which is it is not a trade secret. The vast majority of trade secret cases, if you are tasked with defending such a case, you will be raising the it's not a trade secret merits defense. There are right ways to go about doing that, and there are wrong ways to go about doing that. I'm going to tell you the right way. In many trade secret cases, the plaintiff will come at you with a laundry list of supposed trade secrets. Often, as these allegations are pled, they don't even hold water in terms of being real trade secrets. For example, I've litigated a number of cases where the alleged trade secrets were things like, for example, methods, business practices, business plans, software, system architecture, customer lists, financial records, etc. And the list goes on. The problem with these types of allegations is that if you don't pin them down, if you don't get them locked down in specific terms regarding what is actually at issue, that will make the case impossible to defend. Now, a skilled practitioner on the plaintiff's side will go like a laser at the actual trade secrets. There are, however, some plaintiff side trade secret lawyers who just want to cast a broad net, and their goal is to get that case as far along as possible without being forced to state in specific terms what the trade secrets are. Their goal is ultimately to get past summary judgment, possibly even get to trial on generic, vague, wishy-washy categories of trade secrets, because in their view they have a better shot of prevailing, tricking a jury, winning a verdict, and ultimately getting a bunch of money out of the defendant. The best way to counter that is with specificity. So in any trade secret case, your frontline merits defense in terms of challenging the very existence of a trade secret, your first step is get specific. In many states, in fact, the vast majority of states in the country, trade secret litigation is governed by the UTSA. Now, under the UTSA, there is no absolute requirement that the plaintiff plead trade secret allegations in its complaint with specificity. Only certain states have adopted such a specificity requirement, among them California. What this means is that at the complaint stage, the allegations may be very generic. So it's incumbent upon the defendant, upon you, to force the plaintiff to specifically identify the trade secrets at the earliest possible juncture. What's that look like in practice? Well, you're going to lock that down through discovery requests for admissions, interrogatories, depositions. You're basically going to ferret out what the plaintiff means by software, what they mean by business plans, business methods, financial data. If it's a database that's supposedly stolen, you're going to lock them down in terms of exactly what that was, exactly what it contained. Once you get the trade secrets specifically identified, you're going to move on to step 2, which is basically to disaggregate. Many people fail to understand that in defending a trade secret claim, you have to break everything apart and you have to treat each one of the claimed trade secrets as a mini trial. So effectively, in terms of structuring your defense, we will actually open a file in our software, specialized software that we use. And underneath the case, there will basically be 14 branches of the case. That's an example. If the plaintiff alleges 14 different types of trade secrets have been stolen, we will actually have 14 different mini cases built out within the case. That's disaggregation. Because what we're going to do is we are going to attack the claim of trade secret with respect to each and every one of these 14 different allegations. We're going to build effectively a case file and a case for each of these 14 different trade secrets. So you have 1, get specific. You have 2, disaggregate them. So you can have a mini trial on each. Now, what goes into that mini trial? Let's focus on 3. In my view, when you get into the it's not a trade secret merits defense, there are really 3 core aspects of that defense, and you should run each of these to ground. The first variant of the it's not a trade secret defense is that the information is not unique. So once you have discerned exactly what the trade secret is, and in order to get this information in a full workable picture, you need to ferret out what is the trade secret, who developed it, when was it developed, who had access to it, how was it kept confidential, what was its value, do competitors have access to it. Collectively, from this information, you're going to build your defense into one of these 3 variants. And it's either going to be that it's not unique in that it's readily accessible to other competitors in the industry. Other competitors have something comparable. They can purchase it commercially for not a significant investment, etc. It's not unique. 2, it's not secret, meaning it's been disclosed. It's been given to somebody. I've seen cases in which a company had something that could have been a trade secret, but it was disclosed to an employee who didn't have a confidentiality agreement, or to a contractor or subcontractor who was not bound by confidentiality provisions. And the courts have said it's not secret anymore. So maybe it's unique, maybe it's valuable, but it's not a secret anymore. So you got 2 variants, unique, secret. The third is it's not valuable. It may be unique to you, you may keep it a secret, but I may be able to prove that it lacks economic value. One of the biggest benefits of getting specific laying out all the different trade secrets one at a time, disaggregating them so you can build a case file on all 14, for example, and then mapping out all this information onto each of those 14 categories of trade secrets. One of the biggest benefits of this is that, yes, in some instances, you may be able to win the case overall. You may simply have a home run defense that defeats everything. But in many cases, you will not have a home run defense, and you will actually have to fight it out on each of those different categories of trade secrets. And when you disaggregate it like this, sure, maybe you win them all. But even if you don't win them all, you can still pick many of the categories off. So let's say there's 14, and you can actually pick off 10. Then you're down to actually having 4 of the alleged trade secrets go to trial. And the obvious benefit there is, if you've done things correctly, if you've done it the right way, if you've done your homework, if you've built the mini case file on each of the trade secrets, the remaining 4 that are going to trial, you should have something in your arsenal regarding the value of those 4. So the plaintiff may have come out of the gate saying you stole 14 different categories of trade secrets. The overall value here is $20 million. Well, if you manage to get specific, disaggregate it, build the case file on each of these claimed trade secrets, you should get it to a point where you're able to whittle down whatever those damages are. And you're able to say, okay, these 10 are completely off the table. Now let's have a trial on these 4. And even if you are able to prevail in showing that we misappropriated these, the value here is not $20 million. It's $700,000, because we've disaggregated everything and we've calculated what the value is just for these 4 particular trade secrets here at issue. So it's a bit complicated, it's a bit heady stuff, but from my experience, this is a basic overview of the best way to pursue the number 1 merits defense of it is not a trade secret. So let me briefly attempt to recap this. Number 1, you've got to get specific. You're going to be dealing with a generic laundry list of trade secrets. You have to lock the plaintiff down in terms of what that specific trade secret is, what is actually at issue. Then you can disaggregate it into 7 or 10 or 14 different categories, whatever the number may be, and you build a case file on each of those claimed trade secrets. So you're basically going to have a sort of mini case on each individual trade secret. Within that mini case, you're going to go after all of the critical information in terms of when was it developed, who developed it, who had access to it, how is it kept confidential, what do competitors have in that same space, etc. Everything in the kitchen sink. You're going to be looking specifically for 3 different variants of the it's not a trade secret defense. It's not unique, it's not a secret, it doesn't have value. The goal is to whittle it down. Obviously, you want to try and get all 10 or 7 or 14 completely taken off the table, prevail at summary judgment. But even if that's not the case, and you have to go forward, you have to try this case and defend it at trial, you're going to try and whittle it down so that at the end of the day, you're only dealing with defending against 2, 3, 4 claimed trade secrets, and you have done that much work to reduce your potential exposure. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. I have a nationwide practice in non-compete and trade secret litigation, particularly with respect to trade secret litigation. I just want to point out that trade secret litigation is very uniform. Most states have adopted the UTSA. So in trade secret cases, courts in one state will routinely rely upon other states' interpretations of the UTSA. So in that respect, a trade secret national practice is a very logical thing to do. So whether you're in Florida or elsewhere throughout the country, if you have a trade secret related question or concern, please feel free to contact my office. I'd be happy to talk. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale. Thanks for watching and have a good day.